Please be seated. We have 3 cases to be heard this afternoon, and we'll call them in the order presented by our revised docket. The first case is the lien holder Diane Kogan versus Willie Harvey Jr. and Drexel Wells.
Thank you. Please, the court. My name is Brian Stokes. I represent Diane Kogan in her capacity as Commissioner of the Pennsylvania Department of Insurance. I'd like to reserve, if I could, 4 minutes for rebuttal. Thank you. The issue in this case, Your Honors, is whether Mr. Harvey, after 5 years after his accident, some 2 years after litigation, during which at every opportunity he asserted that all of his injuries, all of his damages, all of his medical expenses, and all of his wage loss were the result of his January 2000 accident, and as a result of that received workers' compensation benefits, can then subsequently, after he has settled against the tortfeasor, now claim that no, every medical bill from March of 2000 after his second motor vehicle accident should be allocated to that accident and that accident alone, thereby reducing his lien, thereby reducing the recovery of the Pennsylvania Department of Insurance. As you know from our briefs, from what we submitted, we submitted that argument to the trial judge, who, in a 1 or 2 page order, simply allocated everything after the second accident to the second, everything that was paid after the second.
So the trial judge knew this, right?
Yes, sir.
Knew that this was, and your argument was, I guess it's some kind of judicial estoppel, right?
Well, it was twofold. Actually, it was threefold. Number one was that there was judicial estoppel. That is, you can't take a position for years in litigation, use that position to your advantage to drive up your settlement, and then having once driven up the settlement and accepted the benefits, now say, now I want to reverse fields. I want to go 180 degrees differently, and claim you can apportion.
Well, this wasn't deceptive to the trial court in this case, because the trial court in this case was fully aware of all of these things and simply didn't.
But he placed, what he did, though, and what I would submit as part of his error, was that he seemed to accept the fact that because the defendants knew, that is the Dextrol and Wells, the cement company, because they knew of the second accident and because there was some testimony that he had returned to work, that somehow meant you could now allocate everything incurred after the second accident to that accident and take it out of the lien as it would relate to the first accident. When there was no testimony, there was no...
Well, wasn't the fact that he returned to work significant, returning before the second accident significant in allocating, let's say, wage loss to the second accident?
Well, except that Mr. Harvey took the position under oath in his deposition that he had not received a cure. He had not received a miraculous cure before his second accident. He said, I went back to work because I had to, because I had bills and I had family. And he also indicated under oath in his answers to interrogatories that he was out of work for almost over a year. He never indicated in his answers to interrogatories that he'd returned back to work. And in fact, he always had taken the position that the second accident caused a temporary, and I think he said in his deposition, a 3 or 4 week period of time where he hurt a little bit worse than he had after the January accident. But then afterwards, he went back to his pre-March condition. And there was no medical testimony presented to Judge Stetson that would allow Judge Stetson to apportion the medical bills and the medical expenses and the wage loss between those two.
Well, you weren't denied the opportunity to present evidence on this, were you?
Well, no, but it wasn't my burden. It was Mr. Harvey's burden to come forward and say, we can apportion it, and here is the evidence to apportion it, because it was his motion to determine the amount of the lien. It wasn't until he comes forward with evidence saying, admissible evidence, saying, I can allocate between accident 1 and accident 2. I submit to the court it's not my obligation to come forward with any evidence.
Well, nobody's suggesting it is, Mr. Stokes, I don't think. But it seems to me you're making 2 different arguments here. One is a judicial estoppel argument, which is a question of law. And the argument you're making now, if I understand it correctly, is that there's no competent substantial evidence to support the trial judge's findings.
That's correct.
Now-
Well, that's
now,
true.
Do you intend to make those two separate arguments?
Yes, sir, I do.
Okay, because even if there's no judicial estoppel, then I take it your position is, even if he wasn't judicially estopped, it's still error because there's no competent substantial evidence.
Yes, sir. And related, I think.
Because the standards of review are dramatically different for those two arguments.
And I'm aware of that, and I would submit to the court that whichever standard you apply, the result is the same. That is, that the trial judge erred and simply arbitrarily say, everything after March, we're going to allocate to the second accident. And therefore, everything after that was paid after March, the March accident, gets attributed to that accident, which in turn drives the lien down. Related to the first point, though, of estoppel, I also submit that Mr. Harvey was obligated to get my client's permission before he settled his third-party case.
Any Florida law that suggests that?
Well, I haven't found any case law that says that, but the statute that I referenced in the notice of lien that I filed with the trial court, and the statute says that in any action, in fact, I have it in my brief, but it says in any action in which benefits have been paid, the third-party claim cannot be settled without the permission of the claimant or his beneficiaries and the carrier or the employer, whichever is applicable.
But isn't that statute in the context of a lawsuit by an insurance carrier under subrogation or something such as that?
That's the first part of the statute of 440 paren 4. 440, paren 4.1. 4B, as I recall, says the action reverts back if the insurance company does not file between year 1 and 2, then the cause of action reverts back to the employee, in which case all the rules are applicable again.
So, but I mean, just to carry that point a little further, Reliance, it's an unfortunate name, I guess, for this insurance company, but Reliance could have filed a suit under its right of subrogation against the third party, could it not?
It could have,
but didn't do anything for years, right? I mean,
well, but it has to be kept in the context of that in October of 2000, some 9 months after this accident occurred, during which time the right was reserved to Mr. Harvey exclusively. Under the statute, Mr. Harvey has the exclusive right to bring the lawsuit from the day of the accident through the first anniversary. Between year 1 and year 2, the carrier can, if it wants to, bring suit. And after year 2, it then reverts back to Mr. Harvey, and it is his exclusively and remains his until the end. Right before the time period for Reliance to bring their own lawsuit, if they wanted to, occurred, they went into liquidation. All their files were being turned over and moved around. So you have to put it in the context. This isn't a situation where Reliance simply said, we're not going to do anything. In fact, when they were contacted by Mr. Harvey and said, hey, we understand you have a lien, what is it, because we're in suit, they immediately wrote Mr. Harvey's lawyer and told them what the amount was. They retained me. I put a notice of appearance and notice of lien in the file, and I stayed available to do whatever I could to assist Mr. Harvey in resolving his claim, including, as I think I mentioned in the brief, being available for mediation so that Mr. Harvey could make an informed decision. We could get people and say, this is what we would want back if you settled at this level, and they didn't do anything. In fact, Mr. Harvey never objected to the amount of the lien, never claimed that it was too much until after he settled his claim.
He doesn't have to do any of those things, does he, under the statute or the case law?
He has to notify us.
But he doesn't have to object to the amount or anything else, does he?
Well, perhaps that's correct, Your Honor.
Isn't it your burden to prove the amount of your lien?
Which I did. I came forward and I said, here's the amount of the lien. We had allocated it based on representations that Mr. Harvey made to us, including a stipulation in his workers' compensation claim where he indicated under oath that he had experienced a temporary aggravation of his injuries from the January. We allocated it to the first accident. The burden then, when Mr. Harvey files his motion, is for him to come forward with evidence that says, now you can allocate I can allocate between accident 1 and accident 2. In fact, the evidence that was before Judge Stetson was that no one could allocate. One doctor, Dr. Buckingham, said, I don't think this man has a permanent injury as a result of either accident. And the second doctor, whose name escapes me at the moment, says, I can't tell you whether the second accident has contributed to his inability to work and the restrictions. So the only evidence before Judge Stetson was you can't apportion between these two accidents. And the law in Florida under the Lyons case is if you can't apportion, then it all gets allocated to the first accident. The first tortfeasor carries the burden. And I submit that that's what happened here. That is, the first tortfeasor, faced with that, paid it as if they were on the hook for everything. And now Mr. Harvey wants to reverse position and say, having recovered based on the fact that the first accident was responsible, I shouldn't have to reimburse the comp carry. This is not a situation, as opposing counsel has suggested, where we're trying to we're trying to get 2 liens paid out of one recovery. We're trying to recover for 2 accidents from one recovery. We're taking the facts as Mr. Harvey characterized them and asking that we be treated appropriately under those circumstances. I see I have about 4 minutes left, so with that, I'd like to sit down and reserve the remainder for rebuttal. Thank you.
Your Honors, Richard Sherman for Drextual, and this is David Black for the co-appellee, the plaintiff. And I want to thank Your Honors for moving the order of the cases with the weather forecast. It could have been a problem getting to the airport, so I thank you very much. We're going to divide a time 7.5 and 7.5 minutes. The bottom line is that Gross v. Lyons says that if there are 2 accidents and if the damages cannot be apportioned, then you can recover for all in either one. Now, he looks over the if you cannot divide them and says at any time you can recover for all, and that's not what the case law says. And this went to an evidentiary hearing, or I can say a quasi-evidentiary. People didn't present witnesses, but people presented this was the interrogatories, this is what Dr. so-and-so, and there was no objection. This was an evidentiary proceeding. He handled it in this way too, and the judge made findings of fact. And the bottom line is that the medical bills for both accidents were $23,000, and the plaintiff only recovered $35,000, so it was pretty clear he did not recover all of his damages for both of the accidents. So we're here on an evidentiary hearing. If there was any one piece of evidence that supports the ruling by the trial judge after an evidentiary hearing, then it must be affirmed, and there are 5 clear pieces of evidence. One piece is the plaintiff quit treating almost a month before the second accident. Second is the plaintiff returned to work a month before the second accident. The third is the report of Dr. Buckingham found the plaintiff had no permanent injury from the first accident and was totally healed from that accident. The fourth piece was what I just mentioned, $23,000 of medical bills for both accidents, and he only recovered $35,000. That's kind of hard to come in and argue that he recovered all of them with that when that's all he recovered. And the next piece, the fifth piece, the plaintiff only settled with a tortfeasor from the first accident and not the second. So one piece of evidence is sufficient, and here we have 5 pieces of evidence. Now, he argues that whenever an attorney argues a position to try to increase the settlement value of the case, then they can't later repudiate or change the position or whatever that is submitted. Now, maybe if there was a final judgment where they did recover it all, it would be one thing. But that case was settled. The tort case was settled, and there is no estoppel by judgment when there's no judgment. And he keeps overlooking the fact that because there's no judgment, there's no estoppel. I mean, he made that position in the case, in the tort case, but still he only recovered $35,000. He had total medical of $23,000. So it's pretty clear that he did not recover all of his damages.
Now, your client is aligned as an appellee just by operation of the rule.
Right.
But what is your client's interest in affirming this judgment between these other 2 parties? I'm not sure I follow that.
Well,
I mean, you have a right to be here and argue.
Sure.
It would help me
I
understand.
understand.
It would help me understand the case a little better just to know that. I don't,
Right.
It's not apparent to me.
okay. Well, you're right, but we called upon them, the plaintiff, to indemnify us and, defend and indemnify, and there were complications in that, and so that's why, and then he was making it looked like he was going to make the argument that the settlement must be set aside because he did not approve it. So just to make sure that they didn't do something to prejudice our position, I mean, that's
I
why
see.
we're here.
So this makes a difference to your client for some reason related to the way in which the case was settled. Is that
Right, yeah,
Okay.
yeah, right. If there weren't that contention, we may well not be here, but that's it. So it's just, like I said, this was an evidentiary hearing. He didn't object to the evidentiary hearing. He went there and presented his own evidence, and so one piece of evidence is sufficient. We have 5, and I think there's no basis for overturning the trial judge. Thank you.
Good afternoon. My name is David Black, and I represent Mr. Harvey in this matter. I'd like to briefly discuss with the court the issue of the appellant's party status in this issue. I believe Florida Statute 44039-3A correctly defines the appellant's position in this litigation. 44039 states that an appellant is only a lien holder to this case. There's no actual party status of the lien holder. On January 14, 2004, the appellee, Mr. Harvey, initiated this lawsuit some almost 3.5, 4 years after the actual accrual of the action, the actual auto accident. As a result, more than 2 years had passed, and the appellant missed his opportunity to file a lawsuit. Therefore, the appellant can only be a lien holder to this action. The appellant continually relies upon subsection 4A as his position as a party. 4A clearly states that if the injured employee fails to bring a lawsuit against third parties within the 1 year, the employer may file a cause of action either in the employer or the employee's name. That never happened in this case, so therefore he's not a party. As a result of his non-party status, his ability to claim judicial estoppel is also ineffective. As the court knows, the Florida Supreme Court case of Bloomberg v. USAA Casualty, Inc. discusses at length the ability to work an estoppel. And a number of the elements are, one, there must be a judgment in the case. That didn't happen here because this case was settled in the lower court. The other is you must be a party to the same action. No representations, no issues were ever presented to the appellant in the lower court because those were issues of liability and damages. So that being the case, the appellant cannot claim estoppel. The other issue that I'd like to discuss is the standard of review. As Your Honor mentioned, there are 2 distinct differences between the issue of abuse of discretion, namely, was there evidence presented at the appellant hearing versus de novo review of any questions of law. The only question of law which I believe the appellant has raised is Gross v. Lyons. And in that case, a determination was unable to be made by the trier of fact, the jury in that case. In our case, the trier of the fact was the trial judge. And because he was able to apportion the damages between the 2 cases, we don't feel that Gross v. Lyons applies to these proceedings. That's pretty much my stance. If you guys have any questions, I'd be happy to answer them. If not, I'll rest. Thank you.
I want to make clear, I'm not complaining about the process before Judge Stetson. To make things more efficient, we relied on records and we exchanged them. I'm not complaining of that process. What I'm saying is what was presented to Judge Stetson was inadequate for him to pick a date and say, from this date forward, everything goes to accident number 2.
Mr. Sherman identified several facts, or what he said were facts, that seemed to suggest that you could determine which portion of the bills went to accident 1 and which portion went to accident 2. One is that apparently Mr. Harvey had stopped treating before the second accident. A second is he went back to work before the second accident. Why aren't those facts upon which the trial judge could rely?
Because that was never Mr. Harvey's position during the course of the litigation until after he settled.
But see, now you're going back to the estoppel argument again. I need you to tell me why, from a competent substantial evidence viewpoint, putting aside the estoppel issue, which is an issue of law, why those facts alone wouldn't be sufficient to support the apportionment.
Well, because you can't take one item in isolation. I think the trial judge was obligated to take everything as a whole, and when you take
Is he really?
I would submit that he was, because otherwise you could find one piece of evidence and hang your hat on it and say that's...
Isn't that what the law says? As long as there's some evidence to support the decision, it doesn't matter whether there's oodles of evidence to support a contrary decision?
Well, but we take those and we're taking them somewhat in a vacuum. First off, to say one of the 5 points is he didn't settle with the second tortfeasor ignores the fact he never was able to identify the second tortfeasor. Number 2, that he went back to work. Again, his testimony is he went back to work not because he was cured, but because he had to. The third one was there were $23,000 in medicals. That's not correct. There was $8,000.
What about the one that he stopped treatment? He wasn't treating anymore until after the second accident.
Well, I would submit that in and of itself is not competent evidence to say that everything after the second accident should be allocated to the second accident. Mr. Black argues to you that somehow I wasn't a party, my client was not a party to the underlying lawsuit. Again, he flip-flops his positions. He filed the motion, he asked the court to adjudicate my rights as if I was a party, but now wants to say that somehow the doctrine of judicial estoppel wouldn't be applicable because I'm not a party.
To adjudicate your rights as a lien holder.
Well, but then I'm a party.
That doesn't make you a party to the litigation.
Well, I beg to differ, Your Honor.
You're entitled to.
The fact is my rights were being adjudicated here. I think that entitles me to participate. I made myself available for mediation, made my client available for mediation. If we had not done so under the statute, our failure to cooperate with Mr. Harvey could have been used as a defense to our lien claim and could have potentially reduced the amount to which we were entitled to recover. So we were obligated to participate in that litigation, more so than as just simply a lien holder who has a lien who sits there and waits for a result to happen. The last point I want to make in the few seconds I have left, 44039, paren 4, paren little b, that Mr. Harvey's counsel wants to keep ignoring, makes it clear that once it reverts back to him, then the provisions of paren 5 and paren 3 are applicable, and therefore I think we get into the issues I've raised before. Thank you, Your Honor, for your time.
Okay, that concludes this. Please wait